Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for Am I muted now? Hopefully not. Good, because that was the only one. That's the only fix I could find for that. So luckily we fixed that. Okay, so what was I gonna say? You guys gotta give Streamlabs a minute. Maybe he's coming. Maybe she's not. I don't know. Maybe they are. I don't know Streamlabs gender. So earlier today I did a stupid. And I froze this pop and it froze solid. And I think that gets rid of the carbonation. You know. I'm just trying to think if I've ignored an email from Streamlabs recently. Might have. Anywho, I hope that everybody's having a good day. I just decided what I'm what the fuck? Oh my goodness, things are going crazy today. What am I having for dinner? I already decided what I'm having for dinner. I am having for dinner a baked potato with like fully loaded with a Caesar salad. That's what I'm going with. I'm very excited about it. Tell me what you had for dinner. If you didn't like what you had for dinner, tell me what you wish you had for dinner. Today, slightly less formal than the last 2 days. The videos we will be watching probably won't be posted afterwards until later because I haven't made them yet. We're just going to watch some raw dog court. KFC. Ooh, that sounds pretty good. I can hear. So for any of you that might be on the Discord, I posted recently, shocking, I know, a video of my microwave because it goes back and forth instead of around. And, but the microwave is on the floor, which is like ghetto. Apparently whatever happened spurred the man in this house, my roommate, to install this microwave. It is now on, I think, day 6. I'm trying not to talk too loud because he's in a mood. Update. First update didn't have the right bolts. Second update didn't have the right bracket. Third update didn't measure properly. And then fourth update, which just happened, literally why I'm late, was because I was trying to help them. And listen, everybody knows when you put one foot on something as like a steadying, but you're not putting your full weight on it. Like, do I look stupid? Anyways, so I put my foot up on the stove, just the edge of the stove, because we're mounting this microwave above the stove, and he screamed at me like as if I had put my fat ass right on top of it. Spoiler alert, done that before. But I'm not going to say that, obviously. But anyways, so I can still hear them going at that. I've let them be. I gave them I said, why don't you trace the top of the microwave with this big piece of paper and mark the holes, and then hold that up to the place where you need to do it and mark the holes. And they said that was stupid. I was like, really? Seems easier to hold up this giant, heavy ass microwave the whole time and yell. Okay. I gotta go live. But that's a meme in this house too. I'm always live when things need to be done. I think most of you know my schedule. It's in the evening, but everyone here seems to be always surprised when I'm live. There's fucking bug flying around too. I'm getting pissed off. Streamlabs isn't working. Anyways, let's get on to some court. We're gonna start in Judge Brian Kirkham's courtroom. I have 2 hearings from him, and then we're gonna go to bond court in Travis County, and then we'll see. I already told you about my dinner. Yeah. Microphone's working. Yeah. Good. Feeling good. Oh, though the problem with the Coke is that I think all the carbonation's gone for the most part. Not good. Tell me about it. Tell me about it. You know? Whatever. I laugh. I already did research on this microwave because it is a back and forth microwave, and that's unusual. And I found a Reddit thread about it, and it's about the exact same microwave. So, anyways, here we go. Oh shit, slamming.
Just a moment, and we'll get the record started here. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Wednesday, April 17, 2024 at 8:34 a.m.
Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you. Before the court is Luke Van Valkenburg of case 2311.
No way. No fucking way his name is Luke Van Valkenburg. Somebody has got to fact check that. Is it going to be Tom? Tom, thank you. Yay. Do. Thank you so much, Tom. Awesome. Oh, serious banging now. I'm a little afraid to go look. Thank you again, Tom. Glad that you're here, Chuck and Chick that rants about everything. Oh, I did a double wink there, which is mostly just closing one eye at a time. MB, you're here. I know you've been on Replay Crew lately. Thank you so much. I'll appreciate that. Thank you. Is he wearing one of those like safety outfits? at the jail. Let's call it a safety outfit.
To DP. Mr. Van Valkenburg is here today after failing to appear before this court on March 13th, 2024. For the record, that was a bench warrant hearing. Mr. Van Valkenburg had previously failed to appear before the referee. A bench warrant was issued, and then he paid the entire bond prior to having a bond review hearing, and then failed to appear for the hearing. Bond is currently set at $500. This is the second bench warrant. He reports no employment. Last payment made on this account.
MB, last payment made on your account. Thank you so much. Happy that we can keep you sane. I don't know where you're getting that, because it sure ain't coming from this lady. Insanity. But I'm so glad you're here, and thank you so much. I really appreciate your support, and I'm glad that we can be there for you. I hear you. I hear you. I love your comments, by the way. Like, yesterday you caught that guy yelling out the car. I was like, what was he yelling at? Hilarious. Oh, thank you again. Oh my God. StreamYard, you suck. Streamlabs suck. Y'all suck.
Was a $500 bond forfeiture on April 3rd of 2024. Further, the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 24th, 2024 at 8:45 a.m. before this court.
Okay. Mr. Van Valkenburg, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on April 24, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I do not have money, but my family may have some money. I don't really know what's going on. I don't know anything about court. Like, I really don't understand anything like this. I've been homeless for 4 years. I've been living on the streets in my vehicle. Like, I don't understand anything. I don't get any mail. I don't know. So,
Okay. Well, what you need to do is you need to find a place where you can get mail at somebody's address, give that to the front of the court, and then they will give you hearing notices so that you don't miss those things, because they'll continually send you those.
yes. It's being sent to my mother, but everything's like delayed a week or two. She's always going down to Alabama. She has a rental down there, so she rents it out and she has to fix it up. But yeah, everything's always delayed.
There's always a story. Tom, look at you gifting memberships. Thank you so much. Also, make sure that you've turned on gifting. If you're just getting here, tell me what you have for dinner. If you didn't like what you have for dinner, tell me what you wish you had for dinner. I'm having later after this, unless somebody convinces me otherwise, and half of me wants to convince me to have pasta. Yeah. Grim, you're here too. Love it. And thank you again. Thank you guys so much. Hi, Alicia, by the way. Welcome. Yeah. You're so sweet. 5 months. Oh my God. I gotta get a special day. The internet is so fast and yet still. Okay, let's go and thank you. Okay.
Like a week or two to get into my hands, like my mail anything like that. That goes
Okay.
to her. But, okay.
Well, what I'm gonna do in this matter is say, how much was the bond last time, Mr. Chapman? That
It was $500.
was five, okay. Well, what the court's gonna do is the court's gonna continue the bond at $500. If you're able to post that, you'd be able to be released. Do you have any questions?
So if it gets paid, I'm gone? That's
If
what
you pay the
said?
bond, you're able to get out. That's correct.
Okay,
Update, evidently, they have given up on the microwave. The microwave is still in its place. Now on the counter, at least moved, although taking up an entire counter. And I feel like The Sims. And then they are sitting watching television. So we can count that as a fail, for sure. An absolute fail. Pot pie. I like pot. I like pie. Ooh, last night was better. Homemade pulled pork with mashed potatoes. And you know what? I think that I will be able to satisfy my starch craving with a patate. Un patate. It's a pretty big potato. You know what I really want to do? But here's the thing, even if I do it, I'll get in trouble. But like, I want to sort of do it by myself tomorrow while he's gone. Maybe just like bring in some people and then like just be like, oh, sorry, I thought you were having trouble, so I just took care of it. Oh, that would be a boss move. That would be a boss ass move. Maybe I gotta make some phone calls so I can make that happen tomorrow.
and then my next hearing would be the 24th. Where would that be? Here?
Yes, yes, it will. It'll be at the,
Okay,
what happens is that, there's instructions will be by Zoom. And you can just, basically appear like you're appearing today, except from the jail. You'll appear vis-a-vis Zoom. You can call in or you can appear
Okay.
by computer. So you've got other options.
okay.
Okay?
Now what happens, if it doesn't get paid? How long do I have to stay here?
You'll stay there until the hearing on the 24th.
And what's the date? Sorry.
What's
the
what?
date? The date today?
The date
Sorry.
is the 17th. So you'll stay
Okay.
there a week.
Thank you, Your Honor.
Okay.
Um,
Thank you.
Will I be able to make calls after I get out of here? Because they put me in this like weird thing. They said I was suicidal when I was not suicidal.
Okay,
like the
well,
nurse here.
you'll have to talk to them down there. They control that. They
Okay,
don't have anything to do with the phone.
okay.
Okay, thank you. You're free to go. Have a good day.
No, it's actually a feature of the microwave. I promise, Crazy Cat. It's legit. It's a square plate in the microwave. It's not, or a rectangle, I should say. It's not even a circle like most microwaves are. I promise you, I've researched this microwave. It is working properly.
Thank you. Have a wonderful day.
Now before the court is David Holcomb of case 103162 DP. Mr. Holcomb is here today after failing to appear before referee Coleman on November 17th, 2023. Bond is currently set at $1,001. This is the first bench warrant. He reports no employment. The last payment made on this account was in June of 2023. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on April 24th, 2024 at 8:00 a.m. before this court.
Mr. Holcomb, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose
Yes.
of this hearing is to set a bond that would assure your tenants at the next hearing on April 24, 2024 at 8:00 a.m.
And sorry,
Go ahead.
I was just gonna say, like, I will make sure I'm there. I'm sorry that, like, I know you probably hear every.
We do hear it every day. You're crying about it. Also, okay, so he's made it from November, December, January, February, March, and now we're into April. So what's that, 5 months? Five months. 6 months. Can't count. Never could. Worked at a bank. Was very good at that job. They check your math every day. Like, and they're like, calculator? Yeah, you're allowed to use a calculator all the time.
Thing, but I don't ever remember getting any paperwork on that hearing.
Yeah. Yeah, we do hear it all, Mr. Holcomb. You're right.
I know, and I'm not trying to just sell you a sob story or nothing. Like, I love my son. I try to do everything I can for him.
Let me ask you, are you able to post a bond, sir?
I don't have no money. I mean, I hope someone in my family might, or your friend, but like.
Well, what I'm gonna do, because it's your first bench warrant in this case, I'm gonna reduce your bond the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're free to go. Have a good day.
Thank you, sir.
And I
Not
have a
quite
couple of
free.
bench warrants for the.
Judge, I think it would be better to say you're $200 and you can go. Yeah.
Record, if I may.
Okay.
Kelly Bacon of case 094056DS. LaShonda Burton of case 152095DP. Edward Stallworth of case 22300UE. Michael Atchison of case 091071DS. And John Rockford of case 133868DP. These respondents failed to appear for their referee hearings. Front of the court requests that bench warrants issue in each of these matters pursuant to statute.
Court would enter a bench warrant for Miss Bacon, Miss Burton, Mr. Stallworth, Mr. Atchison, and Mr. Rockford as a result of their failure to appear for their respective referee hearings. Court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater, and further would assess court costs of $150 in each case.
Thank you, Your Honor.
Okay, thank you. Have a good day.
Thank you. You too.
All right, have a good one, Jeff. We'll see you soon.
See you, Jesus.
All right, so let's go to our pro confessor here. Please unmute, ma'am. We're ready for your case. Okay, there we go. Thank you for your patience. This is 2023-2779 DM, Monique Bryant versus Bobby Bryant. It is Wednesday, April 17, 2024 at 8:43 a.m. Defendant is not here.
Ms. Bryant, good morning.
Good morning.
We're going to take some testimony from you, so if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Okay.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
And ma'am, do you have the script that we would have provided to you?
Yes.
Okay, you can go through that now. You don't have to disclose your address, though.
Okay. My spouse and I were married on June 27th of 2019 in Calhoun County at Wilder Creek by a person duly authorized to perform marriages. I was a resident of the state of Michigan for at least 180 days of Calhoun County for at least 10 days prior to filing the complaint for divorce, now before the court. The allegations in the complaint were true when I filed it and are still true today. My spouse and I ceased living together as husband and wife on August 1st. There are 1 minor children born of this marriage, and I, Monique,
1 minor child. I hate to be nitpicky and all, but unless she's talking about like a gaggle of children that mine, I think she's talking that there is 1 minor child.
Bryant, am not pregnant. There has been a breakdown of the marriage relationship to the extent that the bonds of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. If the court were not to grant a judgment of divorce, I would not resume a marital relationship with my spouse. The reason for the breakdown of the marriage is very personal. There are quite a bit of things.
Oh, please tell us, Monique. Girl, we are here to listen to all of your personal issues if you would care to share. Seriously, no, like legit. And if he was a jerk, we'll roast him.
But I'm going to just say that we grew apart and it was
Okay.
time.
That's fine, ma'am.
No.
So we'll find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will note that the court does have the proposed judgment and UCSO in this particular matter that are by consent. Ma'am, they are by consent, so the defendant signed those. Did you recognize his signature?
Yes,
Okay, and that is his signature that appears on those documents.
that is correct. I actually spoke with him this morning. He forgot that it was today, and he said to please just send the message that we agree upon everything.
Does anybody else feel like that's a very suspicious way to handle a divorce? Like, oh, I actually chatted with him this morning. He's not available. No, you will not get a hold of him. But if you were, which you won't, he would say, this is A-okay. A-okay. No problemo. I just don't know what the fucking due diligence is here. Allegedly. Right?
And
Okay, thank you. Court will note the court does have front of the court approval as well. As a result, the court will enter the judgment and the UCSO. That will conclude your case. You are divorced.
I thank you, but I do have a question before it is concluded.
Sure.
He is
Bitch, you divorced. Bitch, before it's concluded, he just said it. What? What are you? What? I've never heard anybody jump in like that. Oh my gosh. Okay, let's hear what her question. What do you think her point is? Are we gonna take bets? Well, we don't take bets, YouTube daddy. You know that. Please don't come at me like that. This is not We Got a Jackpot. What do we think? I don't know. Okay, I know. I think she's gonna ask about last name. Changing her last name. That's all I can think of. Other than that, anything, most anything else, unless it's maybe like just a question.
keeping our home. But both of our names are on it. And I talked to the mortgage company and they said they needed from you, whoever our judge was that granted the divorce, approval to take my name off of the mortgage.
Well, the only thing that the court would do, we don't prepare those. If the judgment of divorce provides that he is to receive the home, then they would be able to do that. Otherwise, you're gonna have to, if you don't have that in the judgment, I don't have the judgment before me right now. If you don't have that, then you're gonna have to do a quit claim deed where you would deed off the property and deed it over to him.
But with that, I don't.
Yum. I love pancakes, Christopher Engelby, known gifter and good friend. I am just like, now this is complex. Yeah, this is not an agreed upon thing with no issue. This is now complex. Complexity.
With the quick claim deed, I'm not sure that would resolve the debt. Also, my name being off of the
It probably wouldn't, it probably would not. So I don't know what the provision is in the judgment. Do you have your judgment in front of you?
Not.
You're telling me neither
do.
of these people had the document in front of them to which they are putting into court record. Is that what we're hearing right now? The judge didn't look at it and she didn't look at it, but they're entering it into the record. Is that what's actually happening here?
Let me get it.
Okay.
But that's what I'm confused about because I don't know. The mortgage company said that they would have to be, because a quick claim deed would take my name off of the deed, but not the mortgage. They said that it was the only way that can happen is if the judge grants that, approves for my name to be off the mortgage and deed.
Well, I'm pulling up the judgment right now, so just a minute.
I put it in there because also the reason why that I called the mortgage to find all this out was because he cannot refinance the home.
Oh,
Because that's normally what would happen is he would just refinance, but he's not able because he wouldn't be able to afford the mortgage if he did that.
I'm not quite sure what you think is, ma'am. They're not going to let you do that. I don't think she understands what's going on here. Then the judge would order them to sell the home. If he can't qualify for the mortgage nor service the debt on his own, then I don't understand. Chris, I will look at Discord after. I hope everything's well. Right? They need to sell the home here. He has to refi or sell it. Like, they don't. I'm guessing she was the boss too.
taking me a little time. I didn't have my computer on, so I switched.
You're okay.
You didn't even have your computer on, Judge? Are you joking? You didn't even have your computer on? Judge! Come on.
I found where the judgment with the personal property and debt addendum, I just wrote in there that the defendant is awarded the following personal property, which
You just wrote it in there and you think that's going to do it? Oh my God. These people are, I love that you guys are thinking of the games that he's playing. What in the motherfuck?
Is that, and in there I did add a note stating this. Just that the defendant cannot afford to refinance the home.
What do you want, a fucking cookie? Just because you write it down doesn't mean the bank is like, oh shit, she wrote it down for us. She wrote it down. We don't need to worry about that then. Oh, as long as the judge knows that he can't afford it, then we're good. Judge is going to pay for the house, right? Oh, no? Oh,
Hold on.
Yeah, but just because she writes it into the thing doesn't mean the bank has to approve him or take her off the mortgage, do they? They might take her off the mortgage, but they won't give him a new one. Also, I found out I'm drinking like 48 ounces of coffee a day, which apparently is a lot of coffee. So I gotta slow that down, apparently.
Well, let me tell you what's going to happen. As I see, you would think that it would take care of this, but at least with the mortgage company, because you have a separate contract with them, they do not have to remove you from that obligation. In fact, it's going to, whatever you do after this, until such time as he refinances or pays it off, it's going to always show in your name. You know that.
Well, that's why I won't be able to purchase a new home. My debt to ratio, right now I'm renting a home for me and my children that is barely big enough for us. And I really would like to.
Yeah, your TDSR is going to be too high, honey. That's the total debt service ratio, ladies and gentlemen. At least in Canada, your TDSR, at least when I worked in the bank, your total debt service ratio is basically how much of your income goes towards paying off your debt every month. And I don't know how either of them would be able to do it unless she is high income, but it sounds like she's not. So I guess I have to keep in mind like the cost of housing is lower, right? In Michigan than where I am. Like, it's sort of absurd to me, some of the people that have mortgages. Like here, a house minimum is going to cost $750,000 plus. So yeah, you have to be pretty rich.
Be able to purchase, and that's why it's so important for my name to be off the debt.
Well, the mortgagee would have to let you off that debt, because what happens, that's a separate obligation. This court can't even order that you would be removed from that. I see it says here, it says that the defendant shall be responsible for the mortgage, insurance, taxes, liens, and other costs. But that, at this point, you know, because the mortgage company is not a party to this action, the court can't order that they would remove you from that debt.
Okay.
So if they do with the order that you have in the judgment, that's great. But I'm just cautioning you that they very well might not do that.
Yeah, well, they said to me, because when I talked to them, they said the only way to do it would be if the judge granted that. That's what they told me was my judge would have to award my name to be off of the debt.
Right. Well, again, what's gonna happen is, it's a matter if they'll take you off it, but I can't order it, at this particular point, other than what you've put in your judgment.
Will you be able to approve it if that's what they need? If it's coming from you, if you approve that, because that's why we agreed upon this. Like, I left everything for my peace of mind and I let him have everything. That was the deal between us, that I would be able to get my name off of the debt and leave my home.
Again, it's up to the mortgage company. Because as I said, they're not a party, so I have no jurisdiction over them. And that's a separate contract action. And I can't, as a part of this action, I can't foreclose them from enforcing their contract rights. So if they're willing, based upon what you have in the, the real property addendum, if based upon that, they're willing to remove you from the mortgage, then you're able to do it. I will just caution you that they may very well not do that either.
So then what would our other option be? To have to sell?
The only other option would be to put in a proposed judgment, a time frame where he has to refinance it or sell it, one of those options.
Okay.
So I guess I'll ask you at this point, do you want the judgment entered as it is now written?
What will that affect if I say no?
Everything, ma'am. You'll be fucking married still. Why is this difficult? What is happening here? This is not a simple divorce. Oh my God. I know he is giving her a lot of advice here. MB says this is divorce 101, quite frankly. Yeah, but she's pro se and he didn't even show up. What do you think about that, MB? Like, what if he showed up and was like, no, I'm not selling the house, or there's so many ways this could go wrong. Sounds like she does have a mess on her hands. The judge thinks he can fix her too. Oh, Tom, thanks so much for being here. You have a wonderful night. Loud. Oh, shit.
Well, then you'll have to go back and prepare another judgment.
Okay.
And come up with something else. I don't want to enter this if you're going to take other action and prepare a separate judgment. And what you might want to do too is you might want to take the proposed judgment with your real property addendum and ask the mortgage company, does that suffice in removing you from the mortgage? Just because it says that he's responsible for that. They might say, no, you have to have a specific provision in the judgment saying that, that you're removed from that, but I can't imagine that they would agree to that.
Hi, Mikey. This girl's in trouble. Little red. Is she red-haired? I think she's got red hair. Anyways, she, bless her little heart, thought that if the judge wrote it, he could force the bank to take her off the mortgage. Yeah, that's not gonna happen. Anyways, the best way to divorce is never to see a judge. That's true. Or I don't know, actually. I've only had that one divorce, He lives. Oh, slap fights. That's a great reminder. Slap fight this Saturday, pregame here, and then we'll head over to the slap fight together, a little pregamed. It's going to be great. 4:20. I don't know what time it is. Mikey will have to tell us the time.
So I don't know what, pretty much there's nothing that I can do besides make him refinance or make him sell the house.
Do you want some time to think about it? I can put this off for about, 14 days, let you think. And if you want to take some other action, then we'll just hold up on this. But I can't just leave it out indefinitely, so.
Okay. No, can you, is it allowed if I ask if I can have like a 3-minute, wait, a 3-minute wait so I can call him?
Well, what I'll do is I'll give you the 14 days. You can call.
I don't necessarily want the 14 days.
Okay, if you want to call us back in an hour or something, go ahead. That's fine. I'm not gonna sign it right now. That way you have time to figure out what you want to do.
I just don't understand why the mortgage is telling me one thing and you're telling me another thing, and I don't know what, it's confusing because that's the only thing that is the holdup, is knowing what we have to do. I don't necessarily, I know for a fact that if I made him refinance it, he wouldn't be able to afford it.
I understand all that.
I don't want to do that.
I'm just telling you that notwithstanding what they have told you, legally, the court cannot order that they remove you from the mortgage.
What if they say, why did they say that then?
I
Like,
have no idea. I have no idea
I don't know what
unless
they're-
you talk to somebody that doesn't know what they're talking about. But the fact is, we have this happen all the time where people they'll have something where they'll put it in a judgment saying that, that the plaintiff is to be removed from the mortgage, and that does not bind the mortgage company. And that issue has been litigated over and over, and so I know that they're not going to be bound by that provision. I'm just saying, if they will accept it, then fine, and they can remove you. But I'm just cautioning you to know, just because it says that doesn't mean you're going to be removed from the mortgage.
Okay, are you willing to put that in there if that's what they want, so that way we can just be done with it?
Well, I'm not going to put it in there. You're going to have to change that addendum and get him to sign that and change it. And then I have no problem if the two of you agree to that. I'll put it in there, but I'm just cautioning you as well that they may not do it. And once you were to contact the mortgage company, they may say, well, we're not bound by that. So that's up to you.
I wish that he would have joined in this. I talked to him and
Yeah.
he said just.
Well, regardless, it doesn't matter if he's here or not. The issue is with the mortgage company.
Right, I know,
Yeah.
but if he was here and told you that he was okay with my name being off of it, would you put it in there? Because that's what they said that they needed when I talked to them prior to mailing for it.
Again, you have a real property addendum that you're gonna have to change to put in. So if you want to contact the mortgage company, find out specifically what they want in there, then you'll have to change it. Because all you're doing in the addendum you have is saying that he's responsible for those expenses. Doesn't say that you're being removed from it.
But if he's responsible for them, wouldn't that make it so I'm not responsible and that I would be able to be
No,
removed?
because you're responsible by contract. So again, go to your mortgage company. If they're willing, if that provision's in there to remove you, you can add that into the addendum and we'll sign it because we don't have any issue with entering that. I was just cautioning you so you wouldn't think, oh, geez, I'm going to be off that when it's likely that that's not what's going to occur.
Okay.
Okay, we'll give you some time and I won't enter this. I'll give you 2 weeks, or if you can figure it out in an hour or 2 days or whatever it takes, you can just get a revised real property addendum to us, and then we will enter it. Okay.
All right.
Thank you.
Do I just get back on this Zoom in an hour or whatever?
No, you'll contact my office.
Okay. All right. Thank you.
Okay, thank you.
All right, we will pause here for now.
Also, if there's holes in the paddle, it hurts more because there's less air resistance and it hits you harder. Just saying. I've heard. Okay, remove that from the studio. Next, we're going back to Kirkham. Let's see how he treats somebody else. Also, before it was fucking up with me on the screen, then now it's work. Oh, Julie JJ's here.
Okay.
Oh, you want it to hurt more? Okay, yeah, as long as that's fine. Well, then you should wet it down first. Get your ass wet first.
Please unmute, ma'am.
It hurts. Maybe during next members only, I'll bring out my giant
Jeffrey.
horse whip.
Okay, yeah, you are still muted, ma'am. Try it again.
Sorry about that.
One moment, please, and I'll call the case. I'll call us into
Okay.
session. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Wednesday, April 17, 2024 at 1:31 p.m. This is case 1993, 913 DM, Julie Jeffrey versus Barney Jeffrey. Defendant is not here.
Ms. Jeffrey, what we're gonna do is have you raise your right hand, be sworn in, because I need to take some testimony.
Okay,
Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Ma'am, you filed a petition to amend the judgment to again have your maiden name of Drum restored. Is that accurate?
Yes, that's true.
Okay. Let me ask you in this matter, have you, since the judgment was entered, have you incurred any criminal record or convictions or anything?
Cole, make sure you and Owen stay out of trouble in Florida. I love you guys. I hope you have a wonderful time there. To be also, I hope Owen's not listening. Well, we'll give it a minute and then I'll come back to this. Good night, Owen. Have a good sleep. Be good for your mama. Oh shit. Anyways, the horse whip that I have was given to me by the lady that ran the horse tour in town when I ran my cruise ship tours. And it is not a toy. It is real. And it's more like a decor item. Like it's like as long as, it's like 8 feet long. It's a real one for like real for whipping horses. I remember when I walked in the door with that though. Oh my God. I was like, hey, look what I got.
No, I have not.
Just so you know, I'm asking that because the statute provides if a person has a criminal record, then it's presumed that they're changing their name for a fraudulent intent. So that's why I have to ask.
No, I understand.
Oh. And when I saw this, I rarely have them where they come in that many years later, so.
Yes, I've been thinking about it for years. I just hadn't got around doing it. I thought
that's
maybe I'd
fine.
remarried, but I didn't.
Okay, that's fine. Well, it's easy to take care of. The court will find in this matter pursuant to the statute, which is MCL 711.1, that the petitioner had filed a petition seeking to amend the judgment of divorce for the name change. She states that she has not had any criminal record since the judgment was entered back on 2/8/1994. As a result, the court will not find that it is sought for any fraudulent intent, simply to restore a maiden name. And as a result, the court will grant your petition in this matter, ma'am.
Thank you.
I will get that signed. It'll probably take a day or so to process. And I say that because once you get that change, you're gonna probably want to take it to Social Security or any, Secretary of State, wherever else you might.
Correct.
Have your name changed.
I will.
Okay. Do you have any question, ma'am?
No, I don't. Thank you.
Okay, thank you, and you have a good day, and like I said, it'll take that much time to probably get it processed.
Okay, thank you very much.
Okay, have a good day.
You too.
So let's go to Art.
That sounds like a good idea. This is not, it's shorter than I remember, but very vicious. Like, this is
Please
vicious. You
unmute
can't hit
everybody.
somebody with it. You could hurt them.
Mr. Wellington.
Yeah,
Okay. All right, so we're ready for
Are we ready for fucking no sleeves in court today? Also, what is on Allie's shirt? And Chris, thank you so much. Love you. Feel better, please. Oh, look how fucking slow that was. Do, 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 do. Does it have a tail? Yes. It has a tail. I'm trying to think of like how I can show you from the
this now. So this is case 2024-301DS. Allie Harley versus Trevor Harley II. It is Wednesday, April 17, 2024 at 1:34 p.m.
Okay, good afternoon to both of you. I guess as I was reviewing this, I note that there was a genetic DNA test completed, but I don't think we have that. Ms. Harley, did you file that, or what's happened with regard?
I asked them if they needed it, and they told me just to give it to you if you needed it.
Okay, well, we would like to have it so we can have it in the file. Do you, Mr. Magnuson, have you seen that at all?
No, I have not, Your Honor.
Okay. Okay, what we will do is we will require that you file that. Let me just do this. Ms. Harley, why don't I have you sworn in, and Mr. Wellington, I'll raise your right hands, have you sworn in, and then we'll take some testimony.
Who wants a beef Wellington? Raise your hand. I do. I want a beef Wellington.
Raise your right hands, both of you. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
yes,
Yes.
Okay. Ma'am, in this matter, you filed the complaint seeking to determine that the child, Joseph Allen Wellington, is in fact not issue of this marriage and is a child born out of wedlock. When you filed your petition on March 15, 2024, were all those statements true, and do they remain true?
Correct.
Okay. You have, as you stated, you did complete the genetic DNA testing in this matter. Does it show, was that testing of Mr. Harley or testing of Mr. Wellington?
It was tested of Mr. Harley. I can show you if you'd like.
Oh,
But I do have it. I do have it on hand, and I can bring it down before I go to work today.
That'd be great, because what happens, I won't sign an order until such time as we get the DNA test results.
Yep, I can do that before I go into work today.
And on that, it'll have a probability of paternity. What does the report state as it relates to probability of paternity?
It says 0%.
And what entity completed that DNA testing?
She said it was testing a different guy, though. That doesn't tell us anything about this dude. I'm confused. Also, if anybody's doing spanking tests, it's me.
The DDC.
And in this matter, if you would, during the time of conception of the child, were you engaged in sexual relations with the defendant?
No.
Were you engaged in sexual relations with the alleged father, Jeffrey Allen Wellington Jr.?
Yes.
And is there any dispute or doubt in your mind that Mr. Wellington is in fact the biological father?
No.
Okay. Mr. Magnuson, do you have any questions of the plaintiff?
Just briefly, Your Honor, ma'am, you are willing to cooperate in the event that we need to establish paternity for Mr. Wellington?
Yes.
And I'm going from memory here, but he has maintained some type of relationship with the child?
Yes.
Okay.
He has been in Joseph's life since day one
Okay.
and remains till this day.
And again, not to be repetitive, but there's no doubt in your mind that Mr. Harley is not the father of this child.
No.
Thank you. I have nothing further.
Where's Mr. Harley? That's what we're confused about. Fletcher boy. Oh, coming in hard with the late fee. I hope your nap was good. Do. Thank you so much. Terrible singer. Terrible singing. She gave her child her boyfriend's last name. Beefy Wellington. You think he's beefy with his shirt like that? Mr. Harley is also in the trunk. Yeah. He agreed taking naps. And she's still married then. This is so confusing.
Mr. Wellington, you've heard the testimony of Ms. Harley in this matter. Do you believe that testimony is accurate?
Yes.
And at the time of the conception of Joseph Allen Wellington, in fact, were you engaged in sexual relations with the plaintiff?
Yes.
And do you believe that, in fact, the child Joseph Allen Wellington is, in fact, your biological child?
Yes.
You have any doubt of that?
No.
And since the child was born, have you, in fact, maintained a parent-child relationship with the child?
Yes.
You understand by acknowledging paternity in this matter that you subject yourself to various financial obligations to maintain and support the child.
Yes.
And are you willing to do that?
Yes.
Mr. Magnuson, do you have any questions for Mr. Wellington?
No, Your Honor.
Thank you. Well, I think based upon the testimony, and I don't know that you don't need any closing argument, do you, Mr. Magnuson?
No, Your Honor. I think clear and convincing evidence has been presented to the court that Mr. Harley is not the father, and then upon presentation of the genetic testing exhibit, I would ask the court to sign an order reflecting that.
Okay. Well, the court has heard the testimony in this matter, and pursuant to the applicable Revocation of Paternity Act at MCL 722.1431 at SEC, the court does believe that the evidence does clearly and convincingly demonstrate that the child, Joseph Allen Wellington, is not issue of this marriage, and in fact, is a child born out of wedlock, that the plaintiff has confirmed that during the time of conception that she and the defendant were not engaged in sexual relations, but in contrast, she and Mr. Wellington were. They both acknowledged that Mr. Wellington has a parent-child relationship with Joseph and have since the date of birth up until the present day. And as a result, the court does believe it's appropriate to determine that the child was a child born out of wedlock and not issue of the parties in this case. And that in fact, the defendant Trevor Harley II is not the biological parent of Joseph. And as a result, once the genetic test results are filed in this case, then the court would be prepared to enter an order to that effect. So with that, Ms. Harley, is there anything else that you have?
I do have a question. So I filed this previously last year when Trevor and I had filed for divorce.
Okay.
I filed for revocation of paternity. And the original copy of the DDC report got filed with that filing. And however, I now have a copy of the original. Will that be okay?
Yes, that'll be all right.
Okay. Okay.
Mr. Magnuson, anything else?
No, Your Honor, thank you.
Okay, Mr. Wellington, anything else from you?
No.
Okay, thank you, and thank you all for appearing. We'll let you go, and you have a wonderful afternoon.
Thank you.
Thank
Your
you.
Honor.
So I guess Judge, send me back that order and I can save it until we get that test results filed.
Yeah.
Let's go on to the other road.
One more. I'm going to put something on the barbecue.
Please unmute both of you. How do you pronounce the last name?
Seifert.
Mr. Seifert, are you there? Please unmute your device. Can you hear us, sir?
Yeah, can you hear me?
Yes, thank you.
Yeah, I'm here.
So now this is case 2023-3317 DP, Benjamin Seifert versus Brittany Seifert. It is Wednesday, April 17, 2024 at 1:43 p.m. Attorney McNiff for plaintiff. I do not have the defendant here.
Okay. This matter is before the court on the plaintiff's petition to revoke paternity.
What
we
is
don't
in
have
the air?
Defendant obviously present.
They're revoking paternity left, right, and center. What is that beard, too? Sorry, it's cold. It just got, you know, that time of the day when it just changes from hot to cold, or like warm to cold. Also, I think it's safe to say I'm now hungry because I am picking at the baked potato. I haven't dressed it yet. Leave it alone, Paisley. Eat it later. You're gonna eat all your starch. Let's get this done.
Not.
Have you had any communication with the defendant, Ms. McNiff?
I have not, Your Honor. We've had difficulties getting responses from her. Even she didn't file a response to our complaint. She hasn't been attending hearings. I think that we had the motion asking for the DNA testing, and she didn't appear at that. You may recall.
Okay. Do you think, Ms. McNiff, that you scared her away or anything of that nature?
I could have. It's possible. Wouldn't be the first time.
Yeah, I'm sure it won't be the last. Ms. McNiff, do you wish to make an opening statement or simply proceed to take some testimony?
I would just proceed to testimony, Your Honor.
Okay. Mr. Seifert, we're going to have you raise your right hand, be sworn in, then we'll proceed.
Okay. Sir, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay, go ahead, Ms. McNiff.
Thank you, Your Honor. You are Benjamin Seifert?
Yes.
And do you know Brittany Seifert?
I used to be married to her.
Okay. And when did you divorce from her?
The divorce was finalized it was April 6th, 2022.
And when you filed that divorce, were you aware or what, do you know whether she was pregnant at that time?
No.
And later, did you discover that she was pregnant?
Yes.
And do you know when she
But they always ask if she's pregnant. Did she lie?
had a child?
April 1st, 2022.
And approximately 9-10 months prior to the birth of that child, had you had any physical contact with Miss Seifert?
Not at all. No physical contact since 2015.
Is that the last time that you saw her in person, or the last time you had sexual contact with her?
I believe both.
And is there any question?
The implications of that are beautiful. So the last time you saw her, are you talking about the last time you had sex with her or the last time you saw her? I think that'd be both. AKA, y'all didn't see each other unless you fucked. That's hilarious. Oh my God. What a fucking crazy day. Crazy day.
In your mind that the child that she bore on and gave birth to on April 1st of 22 is not your child?
No question, not my child.
And do you know that child's name?
Yeah, Isaiah Embry.
And do you know who Ms. Seifert is involved with romantically at this time?
Not right now, no.
Do you know who she was involved with at the time that Isaiah was born?
Yeah, his name's Delshawn Embry.
And Mr. Embry has the same last name as the child that she gave birth to in April of 22?
Yes.
I have no further questions, Your Honor.
Okay, thank you. Anything else, Ms. McNeff?
No, Your Honor, we would just ask that this court exclude Mr. Seifert as potentially being a father of this child, since he hasn't had any contact with Ms. Seifert since 2015, and the child was born 2 years ago.
Well, the court has heard the testimony in this matter as well as reviewed the file in preparation for this proceeding. The court will note that the matter is before the court pursuant to Michigan Compiled Law 722.1441. In this case, the court will note that the testimony has shown that the plaintiff did not have any contact or sexual relations with the defendant since 2015. The divorce occurred on April 6, 2022. And as the testimony was shown that the minor child, Isaiah Kashawn Embry, was born on April 1.
Hold on. So they were married technically from 2015, ostensibly, to 2022 with no sexual contact? How? That's 7 years. Now, that can't be normal. That's not a good marriage.
2022. And as a result, having had no contact in approximately 7 years, that he could not possibly, and it would be impossible for him to be the biological parent of the child. And as a result, the court will grant the petition in this matter and determine that the child, Isaiah Kashawn Embry, is in fact a child born out of wedlock, not issue of this marriage, and that the plaintiff is not the biological parent of the minor child. With that, Ms. McNiff, do you have an order prepared or?
I do not, but I will submit one under a 7-day order.
Okay, thank you. If you would do that, that will conclude the case, and Best of luck to you, sir. I hope everything works out for you. You're free to go. Have a wonderful day.
Thank you, Your
Thank
Honor.
you, sir.
You are not the father. Bum, bum, bum. Bum. Ladies and gentlemen, thank you so much. I think that is all we will do for today. I'm pushing the limits of the computer, avoiding the creed frames left, right, and center. I hope that you've had a wonderful evening. In reality, I'm just hungry. I'm not going to lie. I want to eat. And I need to apply myself to prepare my food properly. I hope that you guys have a wonderful rest of your evening. I will be back at you again tomorrow with more crazy court. What was it gonna say? Oh, slap fighting. So please keep in mind, we have a date on Saturday night. I already cooked the potato in tinfoil in the oven, and then I used it as a hot potato like heating pad for a while. Crazy how long they keep your heat. And then I've just started picking at it, so it's time to eat. Anyways, Saturday night. I don't know what time. Mikey will have to tell us what time it is, but slap fight. We're gonna pregame here. We'll redirect ourselves over to the slap fight, and have a great time. I'm still working my way to get on the show one day. Anyways, I hope that you guys had a wonderful evening. I will do a notification about Saturday. I'll do a post about it. But remember that I love you. I'm proud of you, and I will see you in the next video. Bye.